Welcome to this edition of ABI's Quick Bit video series. I'm Lisa Fox with ABI, and I'm here with Jessica Susie at Gentry. And we had a couple of conversations some time ago about patents and trademarks. And I'd like to drill just a little bit deeper into the different types of intellectual property. Can you expand on that a little bit?
Sure. The four main types of intellectual property are patents, trademarks, copyrights, and trade secrets. Some related types of law are licensing and unfair competition. But as far as the four main types, patents, trademarks, copyrights, and trade secrets. And for example, a trademark is a word, symbol, name, device that's used to indicate the source of goods from one party and distinguish the goods and services of other parties. A copyright is a form of protection for works of authorship, works of expression, such as books, articles, architectural works, drawings, paintings, and the like. A patent is a legal grant from the federal government that gives the owner the right to exclude others from practicing a specific invention. And the types of inventions are machines, articles of manufacture, compositions of matter, and methods or processes. And finally, a trade secret is information that has economic value from the fact that it's not readily known or easily ascertainable, and reasonable efforts are made to maintain the secrecy of the information.
So would a trade secret be something like a recipe?
It could be a recipe. For example, a very famous one is the recipe for Coca-Cola, but it can also include client lists, supplier lists, specific methods or processes for manufacturing an item, chemical compositions.
Gotcha. Well, I would assume that there are similarities in how all of these different intellectual properties are obtained, but I would assume there are differences as well. Can you talk about that?
Correct, absolutely. Well, with the copyright and the trademark, some rights are given to the owner just by using the trademark or creating the work that would be subject to copyright protection. However, both of those items can also be federally registered, so you can register the item with the Copyright Office or apply to register the trademark with the United States Patent and Trademark Office. Trademarks can also be registered with a particular state. As far as the Trademark Office goes, the application is submitted and then an examining attorney will review the application, and sometimes there can be some back and forth about that. With respect to a patent application is submitted again to the United States Patent and Trademark Office, and then in time it's examined by an examiner at the office, and usually there's some back and forth as far as maybe narrowing the scope of the patent or whatever the case may be.
Gotcha.
As far as a trade secret, essentially it's just by keeping the information secret, having that supplier list, that process, whatever the case may be, and keeping it secret and letting others know if you do have to tell them the information that it's secret.
Gotcha. And I would assume there's a difference in the terms for this intellectual property too. So how long? Talk about that.
Well, with a trademark, it can really be indefinite. You start having some rights as soon as you use the mark, and then it lasts as long as you are using the mark. With respect to a patent, generally the term is 20 years from the date of filing, not necessarily the date the patent issues, but the date of filing. With the copyright, it is for an individual, usually the lifetime of the author plus 70 years. And work made for hire, such as an employee situation, would be 95 years from the first publication, or 120 years from the date of creation, so much longer than the patent. And then with the trade secret, really as long as the information is secret.
Interesting. And you talked about a little bit earlier about like Walt Disney.
Right. They've been very instrumental in expanding the term of the copyright.
Of course they have.
So it's very interesting actually when you compare the copyright and the trademark, the copyright and the patent and the difference in terms.
Very cool. Great information, Jessica. Shed some light on things I didn't know about. Thank you again to Jessica Susie with Gentry and all of the members of ABI's Advisory Council who take a really close look at business issues facing Iowa companies and then come up with solutions to solve those issues. So thanks for being here today. Appreciate it.